Welcome to The Explainer. Let's talk about something that can make or break your international business deal. A single clause in a contract. Seriously. Today we're cracking open the legal playbook for navigating international deals.
So you're thinking about doing business abroad, right? It's super exciting. The opportunity is massive. But what's your legal game plan? Because once you cross that border, you're not just entering a new market, you're stepping into a whole new world with a completely different set of rules. And when you sign a contract with a partner in another country, you're doing more than just agreeing on terms. You're basically entering their legal world, a place that might feel like it's operating on a totally different wavelength than what you're used to back home.
And look, this isn't just some small print detail. This is fundamental. It changes how contracts are written, how they're interpreted, and, most importantly, how they're enforced. So, the absolute #1 thing you've got to do, figure out which rulebook you're even playing by.
Okay, so here's the good news. Even though there are, nearly 200 countries out there, the vast majority of their legal systems fall into one of two big buckets: common law and civil law. So what's the difference? Well, think of it like this. Common law, which you'll find in places like the US and the UK, is built on precedent. It's like a path in the woods that's formed by people walking the same way over and over. The law evolves with each new court decision. Civil law, common in Europe and Asia, is totally different. It's more like a super detailed city plan, all written down in advance in comprehensive legal codes, a tradition that goes all the way back to Roman law.
And this core difference has a huge impact on the actual contract you sign. In a common law country, the attitude is basically, if it's not explicitly in the contract, it's not part of the deal. You have to spell out everything. In a civil law system, though, the legal code automatically implies a lot of standard terms. The law kind of fills in the gaps for you.
And here's what that looks like in the real world. I mean, it's pretty stark, right? A contract in a common law country like the US can literally be double the length of a similar agreement in a civil law country like Germany. It's not about which is better, it's just they're playing completely different sports.
And believe me, these differences aren't just academic. They have huge real-world consequences. Take bankruptcy, for example. In a common law system, the focus is often on reorganizing to keep the business alive. But in a civil law system, it's often straight to liquidation, selling off the assets. So the big question is, how on earth do you navigate this?
Okay, to make your way through these different legal worlds, your contract needs two absolutely essential clauses. Think of them as your map and your compass.
First, you need a map. That's your jurisdiction clause. This tells you exactly where a lawsuit would take place. Which country's court system are you going to be in if a dispute happens?
And second, you need a compass. That's your choice of law clause. This one decides which country's laws, which rule book, the court will use to interpret the contract.
And you've got different options here, as you can see. But whatever you choose, you have got to be specific. I'm talking laser-focused. For example, a clause that just says the courts of the UK might actually be unenforceable because Scotland has a totally separate court system from England and Wales. See what I mean? Vagueness is your enemy here.
All right, so you've got your clauses in place. But let's be real, even with the most buttoned-up contract, disputes can still pop up. And when they do, you're faced with a really big problem: the classic home court advantage.
I mean, just picture it. You're trying to take your foreign partner to court, but it's in their country. You're dealing with unfamiliar procedures, maybe even a language barrier, and there's always that nagging feeling that the system might be tilted in their favor. It can feel like a losing battle from the very start. There has to be a better way, right?
Well, there is, and it's what millions of businesses around the world rely on: international arbitration.
So, what is arbitration? Essentially, it's like a private court. It pulls the dispute completely out of any single country's legal system. You get to pick a neutral country, you get neutral arbitrators to decide the case, and the whole thing is private. It's also binding, but its real superpower, the thing that makes it a total game changer, is enforceability.
Think about that. An arbitration award is enforceable almost anywhere in the world. Now, you might be wondering, how is that even possible? How can a decision from a private proceeding have more global muscle than a judgment from an actual national court?
The answer is a landmark international treaty called the New York Convention. Back in 1958, countries got together and made a pact. They agreed that their own courts would recognize and enforce arbitration awards made in other member countries. It's the bedrock of modern international business law.
And look how successful it's been. Over 170 countries are now signed on. That makes this one of the most successful treaties in history. What this means for you is that an arbitration award isn't just a piece of paper. It's like a universally accepted check that you can cash in almost any country on Earth. That is the kind of certainty you need to do business globally.
All right, so let's put this all together. Here's your playbook for success when you're dealing with international contracts. It really boils down to 4 key things. 1. Know the system. Are you dealing with a common law or civil law country? 2. Define your ground rules. Get those jurisdiction and choice of law clauses crystal clear. 3. Choose your form wisely. For any cross-border deal, you should really default to international arbitration. And 4. Ensure enforceability. Make sure your arbitration is based in a country that's part of the New York Convention. You follow those 4 steps, and you're building a solid foundation for your business.
So the next time you're looking at a global contract, ask yourself, is this built to succeed or is it built to fail? Because knowing these rules isn't just legal jargon, it's the difference maker for your success on the world stage. Thanks for watching.